We shall now resume in public session. The purpose of this afternoon's engagement is to conduct pre-legislative scrutiny of the European Convention on Human Rights Compensation for Delays in Court Proceedings Bill. We are joined from the Council of the Bar of Ireland by Mr Micheál Caoimhghín, Chairman, Mr Conor Dignam, Senior Counsel, Chairman of the Council's Human Rights Committee, and Mr David Perry, Barrister. I understand you may have colleagues in the Visitors' Gallery, and I extend a welcome to those also. And from the Free Legal Advice Centre's FLAC, we are joined by Ms Eilish Barry, the Chief Executive, and Ms Sinead Lucy, the Managing Solicitor. You're all very, very welcome. I will shortly invite you in that order, I presume, in terms of your contributions, to make your opening statements. But first, I must draw the attention of our witnesses to the situation in relation to privilege. Please note that you are protected by absolute privilege in respect of the evidence you are to give to the committee. However, if you are directed by the committee to cease giving evidence in relation to a particular matter, and you continue to do so, you are entitled thereafter only to a qualified privilege in respect of your evidence. You are directed that only evidence connected with the subject matter of these proceedings is to be given, and you are asked to respect the parliamentary practice to the effect that, where possible, you should not criticise nor make charges against any person or persons or entity by name or in such a way as to make him, her or it identifiable. Members of the Justice and Equality Committee should be aware that under the salient rulings of the Chair, members should not comment on, criticise or make charges against a person outside the House or an official by name in such a way as to make him or her identifiable. I would now like to invite Mr Micheál Caoimhghín, if I'm correct, to make the opening statement on behalf of the Bar Council.
Thank you, Chairman. Could I first of all say that it's very much appreciated by the Council of the Bar of Ireland that we've been invited to address the Joint Oireachtas Committee on Justice on this bill. We've put together a submission which you may have seen, and that really conveys the points we wish to make. So I'm going to speak to that rather than read it out in any sense, and just to highlight a few of the points that I propose to make. Conor Dignam, Senior Counsel, who's to my right, is going to deal with any queries in relation to what might be thought, what we suggest are perhaps imperfections in the model, in the bill as it currently stands. I'm going to speak more to our main point within our submission, which is the suggestion that perhaps the model that has been selected in the draft bill is perhaps not the best way to go about addressing what is an important matter. First of all, I should really start with that. It's very much welcomed that there is a legislative response to what is an important issue, and that is the fact that Ireland is in default. Ireland is in default in relation to its international obligations, its obligations under the European Convention on Human Rights. And that has been made clear by that court, and Ireland has accepted that in a number of cases. The root cause of court delays is, unfortunately, something, perhaps it's a boring thing to say, but it's something that requires to be said. The root cause is the fact that our courts are not and continue to be properly resourced. That is the difficulty. There are not enough judges appointed, not enough registrars, and not enough backup and support for our judges. And that, if that situation persists, it's likely that the problems associated with court delays will persist. But nonetheless, it's proper to address the concerns raised in the bill. The bill chooses a model which is the non-courts-based model of providing compensation to those who are affected by court delays. And the bill envisages that there would be an administrative tribunal or body set up which would be staffed by a retired judge or judges who would then adjudicate upon the question of whether compensation should be awarded, and if so, in what amount. And the point we have offered is that whilst that might appear superficially attractive to, as it were, take it out of the courts, take it away from lawyers, make it simplified and make it cheaper, those are legitimate and proper concerns, but it's in our submission that, in fact, for the reasons we've set out in the paper, not be in the public interest, we feel, and not be the best way of approaching this issue and delivering on the objectives which the bill is directed at meeting. And one of the reasons is simply one of expense. We say it is difficult to identify a good, valid reason as to why the Exchequer should be hit with the undoubted cost, significant cost associated with setting up a whole new administrative structure, staffing it, resourcing it, paying salaries, paying for clerical staff, paying for an office, rent, buying it, whatever it may be. And for that reason, we say that perhaps isn't the ideal way to proceed. There's a pre-built, already existing, and very efficient structure when it's working well, that is the courts. And this is a case where, in fact, and this is one of the points we make in our paper, the Oireachtas, in earlier legislative provisions, have decided that the best way to deal with meeting our objectives under the ECHR Convention and providing justice for our citizens across a range of legal areas is to do it on the courts-based model. So, for instance, there is a Section 3A of the Human Rights Act already in being, which allows a citizen who has been wrongly deprived of their liberty to go to the circuit court and to make a case that they should be awarded compensation if they've been locked up unlawfully, if they've suffered that indignity of been put into prison without just cause. And that was something, a legislative decision made by the Oireachtas, and we feel it's difficult to identify a good reason why the same model shouldn't be followed here. It's not known quite how many cases, how many plaintiffs seeking relief for court delays there might be. There's likely to be more than those who would seek, more than the number who would have looked for damages for being unlawfully imprisoned. But there may not be too many, and that's the other point. It is difficult to see why it would be justified economically, whatever about the issues of principle, but the pure raw numbers, it's difficult to see how it would be justified to set up an entire new administrative structure for what may not ultimately be a large amount of cases, though that issue is a little bit unknown. So, at a level of principle, in addition to that, we say that given the potential legal complexity that is associated with claims for compensation for breaches of Article 13 and the right to speedy access to justice, and given that the ECHR itself has identified that these claims can be, not always, but can be really quite complex, it is an issue that is best left to the courts, who are well used to dealing with receiving submissions, weighing up competing interests, judging as between how best to give justice where there's been a breach of rights. These are routine matters for a circuit court judge or a high court judge or district court judge, whoever it might be, to add to their bundle of cases, and there wouldn't have to be the extra amount of training that would go with and the extra amount of cost associated with setting up an entire new separate structure. So we think this is something that could be properly dealt with under the existing court structure, and that would be most fair to the citizen, and most of all would be best suited to what is the public interest in relation to these various headings. Now, we say there's a risk as well that if one proceeds down the road of the setting up the separate administrative body, that body itself could be at risk of being judicially reviewed, or complaints made against it on delay grounds, or being challenged for making what might be thought to be unreasonable decisions if it decides to refuse an application for compensation or award too little, the citizen might feel. And these again, because of that, we feel that is a further standalone ground for leaving these to the parties that are best equipped to deal with these issues, who are trained judges, who are independent and who are well used to dealing with legal cases and the complexity of legal issues. Now, we've made a number of recommendations in our paper that you may have seen, and what we've suggested is that these matters be left to the courts, and perhaps there should be a similar model chosen along the lines of Section 3A of the Human Rights Act, and simply creating the statutory remedy of going to court and allowing that to be done. As to which court, that will be a matter entirely for the legislature, of course. We don't think there's any particular reason to depart from the pre-existing model of doing it in the Circuit Court, or perhaps leave it in the High Court, but that's entirely a matter for the legislature, and we'd acknowledge there'll be different reasons for choosing as to which comment you might make. It is undoubtedly an issue which has a degree of urgency in it, in that Ireland is in default. That isn't something that is inconsequential, that needs to be immediately addressed. And we feel that delayed claims need to be considered and dealt with properly under the existing and well-provided established structure. The ideal environment for that, for the fair and just determination of these Article 6 breach claims, is the court's model. And taking that approach, we think there'd be consistency in the law. It's already been done that way, and we don't find it persuasive, and matter entirely for yourselves, we don't think that the case for lifting it into and creating an entirely new structure really is, from a practical point of view, from a justice point of view, and from a principle point of view, is the way to proceed. And we'd be very happy to take any questions in relation to the issues arising.
And I would now like to invite Eilish Barry of FLAC. Eilish, are you delivering the opening statement? Please.
Thank you. We also have submitted a more detailed paper, and I'll just speak to a few points that we've made rather than read it out. We're a voluntary independent legal rights organisation that exists to promote access to justice, and we believe access to justice includes not just legal aid but also access to the courts and access to effective remedies and fair, just and socially inclusive laws. We welcome the opportunity to contribute to this pre-legislative scrutiny, and we also welcome that there is going to be a legislative basis in relation to this matter. We also view delays as a major inhibitor of access to justice, and from our work we see that it arises in a number of arenas, including waiting times for legal aid. At the moment, the most recent figures from the Legal Aid Board showed there's up to 42 weeks waiting time for a first appointment in the Blanchardstown Legal Aid Board Law Centre, and over 6 months in a number of centres. The processing times for social welfare appeals, the most recent social welfare appeal report showed that the average time to process social welfare appeals was 23.6 weeks, with 30.3 weeks in the case of supplementary welfare allowance, which is supposed to provide a basic safety net payment. And the most recent report of the Social Welfare Appeals Office also states that 63.6% of oral appeals were successful. And in the Court of Appeal, which was set up, I suppose, to reduce delay, individuals now have to wait for up to 2 years before getting an appeal heard. We're concerned that this committee would look at the issue of delay, not just in relation to the contents of this bill, but as a systemic issue. There's a commitment in the programme for government to commission an annual study on court efficiency and sitting times to provide accurate measures for improving access to justice, and we would urge that this commitment would be fulfilled, that there's a real need to have accurate measures that would measure for improving access to justice. There's also a review of the administration of civil justice ongoing, which has been carried out by the High Court President, Mr. Justice Peter Kelly, and one of the aims of this review is to improve access to justice. So clearly delay will be an issue which will be looked at by this review group, and we would submit that the outcome of this review is a matter which should be of fundamental interest to this committee. And we're asking that this committee would make access to justice a central ongoing feature of its work. Just to turn to the heads of the bill themselves, and I suppose we have 7 basic points to make, which I will go through quickly. Delays that occur before quasi-judicial bodies and tribunals should be included in the legislation, both from the perspective of calculating when proceedings commence and also to be taken into account in determining any compensatory remedy for unreasonable delays that arise in proceedings before such bodies. Whether a delay arises directly in a particular case or arises indirectly through delays in a related case, that shouldn't make any difference to the entitlement to apply for compensation and to be awarded it if merited. Our third comment on the heads of the bill is that the direct linking of any financial compensation payable under the proposed legislation back to the principles and practice of the European Court of Human Rights is problematic and undesirable. And we would suggest that the removal of specific references to the ECHR and Article 41 in Head 8 would provide a more fluid and flexible remedy for course-based delays, and therefore more readily provide a remedy for any breach of EU law that might arise in that regard than the present formulation would allow. The fourth point we're making in relation to the heads of the bill is that, as it is proposed that the assessor would be a retired judge, it is unclear to us why there is a need for a requirement for the High Court to approve awards of compensation, given that it's also the forum for the determination of appeals under the proposed legislation. Fifthly, then, in terms of multiple claims, the proposed bill is silent in relation to further delays that might accrue after an award has been made if the proceedings were not determined by that time, and we believe that the legislation should provide clarity in that regard. Sixthly, where a case is ongoing, in any application for case management before the courts, we believe that judicial notice could be taken of any determination under the proposed Act by an assessor that unreasonable delay has occurred and the reasons for the same. Finally, in relation to costs, there is no provision under the heads of the bill for expenses of making a successful application to be discharged by the state or minister, which inevitably will mean that such costs will be taken from the award, again possibly undermining the effectiveness of such a remedy. And we're suggesting that this issue could be remedied by providing for a flat fee for each practitioner who assists the client to make a successful application, but in turn requiring the practitioner to undertake not to seek further payment from the award. So there are summary comments in relation to the bill, and Sinead will be happy to answer any more detailed questions.
Thank you, Eilish Gormila Mahagav. So I now open it up to the members. Now, I know that one of the deputies believed his hand was up first, but Deputy Wallace had approached me, and just to indicate that he has. So I'm going to invite Deputy Wallace to go first, if that works, and then it's Deputy O'Callaghan, Deputy Chambers, and Deputy O'Leary. That's the way I saw your hands. Deputy Wallace.
Very much. No, I was actually just letting you know that I had to go away, and I have to meet someone from the legal profession, whether I like it or not. So I'm sorry that I have to rush out, but I will read thoroughly all your submissions so that we're better informed, and I've obviously got a lot to learn about what it's all about. Just one question. You said you find it hard to understand, and I've seen that as I briefly looked at your briefing. You don't see the logic of the state reinventing the wheel, come up with this elaborate new organisation when actually you can do it in a courts sort of in a courts model, which would cost a lot less, seems to be far less cumbersome. Why do you think that the government have come up with this idea that they should invent this new large entity rather than go down the route that you're suggesting? Why do you think they did that?
Thank you, Deputy Wallace. Mr. O'Hickey.
What prompted the legislature, or was it the Department of Justice, or those who were behind the bill, to do it that way? In fairness, I imagine it was that they had legitimate objectives in mind, perhaps to provide it informally, in what thought would be a streamlined way, and bluntly, no need to involve the lawyers. I imagine it was out of a desire to make it as straightforward and as cost efficient as possible was the thinking. But it's our view, respectful view, that perhaps choosing the model they've chosen does not achieve best that objective. But I imagine it was thought that that was the appeal of that road.
Well, I mean, listen, without knowing much about it, it would look to me as if their model is almost bound to cost more. And generally, the government don't make decisions that cost them more money.
Yes.
They tend to go in the opposite direction most of the time. So, is it not blatantly obvious that this is going to cost more?
I would have thought it should be obvious. I do respectfully agree, Deputy Wallace, but it may be that the view was if it's a court-based or caused delay, let's lift it out of the courts to have a compensation system for that delay. Maybe that was the thinking, but again, we feel that wouldn't be a tremendously strong point or a tremendously strong reason to lift it out of the custom-built system that normally adjudicates on the question of competing rights, the courts.
Just to do another point, your opening comment was that the courts are not resourced enough and there isn't enough judges appointed. Given that that's pretty obvious to you, what do you think? Why do you think the government have dragged their feet on changing that situation?
In fairness, again, I imagine it's a matter of competing resources. For every laudable objective, there's another one behind it in the queue or ahead of it in the queue. So it's a question of the legislature choosing between competing interests. But we feel if the ultimate objective is to solve the problem of court delays, that is actually more important than the narrow issue of providing compensation. The first and foremost approach to tackle the problem should be address the root cause of delays, which is the under-resourcing of our courts. And that is the fundamental difficulty. So we think a holistic approach, if you like, should be taken, tackle the full problem head-on, but also address the issue of providing compensation where delays occur.
I genuinely don't know, but do you know how much, what is the cost to the state at present in facilitating the running of the court system?
I don't have the figures on the total figures, but it is. It's oftentimes the state would. These things would be cost neutral, because, for instance, in relation to if the court earns money, the court system earns money from court pleadings and filing charges, so that the more litigation there is, the more revenue will come into the central office from parties looking to get their pleadings filed. In addition, the state earns very sizable income stream from taxation on professional fees of lawyers operating in the system, and also value-added tax on those fees. So, and this is a point that we've sought to make in the context of our proposal we've made to government, which thankfully the government has accepted and has decided to support and back, and that is a proposal to attract in foreign investment and legal services. We call it the Brexit Initiative, to prepare for the strong possibility that the United Kingdom will be leaving the European Union at the end of March. But coming back to your question, Deputy Wallace, I don't have the exact figure of the cost of running the courts, but one thing that shouldn't be lost sight of is that many of these measures actually would be either cost neutral or have a positive cost aspect, in that some of these improvements and reforms in terms of adding to the number of judges and resourcing them properly would actually be self-financing and would pay for themselves. So it's not all about a bad hit on the exchequer. There are positive financial aspects to making these necessary reforms as well.
So if I said to the Minister, listen, why don't you resource the courts properly and get real, and he said back to me, roughly speaking, how much do you think it'll cost us if we were actually to do it the way you'd like it? Is it impossible to put a figure on it?
I don't have those figures, but we do welcome. There's been an indication that there's going to be 6 additional judges appointed to the Court of Appeal to deal with the very great backlogs that are at the appellate tier of the system. That commitment has been given, and we understand that is in train. That will ease the burden, but it won't cure the problem, and it certainly won't address the problem of not having sufficient judges in the High Court, Circuit Court and District Court. But it's a start towards it, but more needs to be done under that heading.
Right, that's my last point. Just on the issue you mentioned about foreign direct investment, just explain that to me exactly. What does that amount to?
Well, the point I was making there was that as part of our Brexit initiative, which, in fairness, I shouldn't say it was just a bar initiative. It was across the legal profession, the solicitors' body as well, and also some law firms. One of the objectives was to make it known and proclaim widely the fact that foreign direct investment, many firms and law firms choose to litigate their business in London because of the access to a common law country legal jurisdiction and also with an overlay of European Union law. If the UK is leaving with Brexit in March or whenever it's going to happen, and hopefully it won't happen, but if it does happen, that will mean that a number of parties and corporations and law firms will want to transact their legal business in Dublin. So that because of the fact that we are the other major common law jurisdiction in the Union, we'll be the really, without being disrespectful to perhaps to Malta and Cyprus, we'd be the main one left, and we would be an excellent choice for that business, and we were anxious to attract that in, and that also has implications for foreign direct investment beyond legal services in relation to that issue. They would move away from London being the hub, hopefully a part of it at any rate, to Dublin being the hub. So it's attractive from society's point of view and from the point of view of the Irish Exchequer as well.
Okay, thank you. And hopefully if the foreign direct investment that comes in this matter doesn't have quite the same negative impact as it's had on the housing section and around selling out to Nana's friends and whatever. Thanks very much. Thank you.
Thank you. We wish you good luck at your next meeting. Okay. Just before I bring Deputy O'Caoláin in, just for the information of the panel, feel free to intervene. You know, Jim may direct his question to Micheál or to Eilish, but I'd like everybody to feel as openly able to participate. There is no need but to just indicate, and we'll call you. Deputy O'Caoláin, please.
And I want to thank FLAC and the Bar Council for coming in and for the very helpful submissions which I've read and which I know, Chairman, the committee will find very helpful when we are producing a report. I think it's important to note at the outset that, you know, it's a very infrequent occurrence for people to go before the courts or to seek justice. People only do it generally about once or twice in their lives. Some people are lucky and they never have to do it. But it is an extremely stressful process, and the good thing about having the Bar Council here, and indeed FLAC here, is that they're aware of the stress that invocation of one's rights and having to seek justice can have on individuals. And I think sometimes people on the outside don't appreciate that. And delay can have a really aggravating impact on that stress. And I know recently there was a woman who was a complainant and she disclosed her identity in a rape trial. But one of the things she said after the accused had been convicted was that the delay of 4 years during which the process went from beginning to end by her making her complaint and the years going through the court process, she found that extremely stressful. So there's a purpose behind the provisions within the Convention on Human Rights as to why that there should be a speedy remedy and why there should be an effective remedy when delay has been introduced into the system. So I just think it's important to say that at the outset. And in terms of other colleagues here, could I just ask the Bar Council at the outset, I suppose when you're looking at delay, maybe I'm wrong in thinking of it, but I suppose there's two types of delay from the court system. And one is the delay caused by a case not getting on for a period of time, if a case isn't listed on the first occasion, doesn't get on the next occasion. And secondly, there's the delay caused by a judge who hears a case not giving judgment on a case promptly. Are they the two types of delay that we're looking at here, do you think?
Yes, David O'Caoláin, I think they are. And just if I could come back to the first, your opening comments in relation to the stress of proceedings and court proceedings, and that's obviously what is being directed in many respects by the jurisprudence of the ECHR. And one anomaly which I think does arise from the Act is that, in fact, a victim or complainant in, for example, a criminal trial who has suffered stress and damage as a result of delays in our system doesn't appear to be one of the categories of persons who can seek compensation under the proposed under the bill or the heads of bill as they currently stand, which does seem to us to be an anomaly. In relation to the delays, they are the two types of delay, the ones you've identified. They're the ones which we have also identified. As you say, the delay in a case getting on because of the shortage of judges or resources in the court system to enable cases to get on when they should, and also the post-hearing delay of a judge not giving judgment expeditiously. And of course, that is not the fault of the judge. That judge finishes one case on a given day and takes up another case the very next morning, and when he's finished that case, takes up yet another case. So the demands on judicial resources are such that it is very difficult for judges to actually provide judgments in cases that they may have heard 2, 3, 4 cases ago within a very reasonable and quick period of time, such as to avoid any complaint of delay. So they are the two principal types of delay.
And in terms of the latter delay, which is after a hearing has concluded, like a judge in that case obviously will have other factors or other issues that they have to deal with. But in terms of the delay, what resources does a judge have in a case like that to write his judgment? Like, I just compare this committee here. We have hearings every Wednesday morning. We produce around 6 or 7 reports a year. Obviously, we have the chairman, the members, but there is about 4 full-time members of staff assisting the chairman and the members in producing our reports. What support does a judge have?
So our judges have our High Court judges.
This is the High Court judge, because it's not a problem in the circuit or the district, is it?
I suppose there can be delays in getting your cases on in the circuit court or district court, but after the hearing, one doesn't experience the same delays because there isn't the same necessity for written judgments or reserved judgments. The resources that are available to High Court judges are, generally speaking, a judicial researcher. They have access to a judicial library, and they have some secretarial support, but only some secretarial support. And that is the extent of the backup that's available to our judges. But I suppose the point has to be emphasised that it is, of course, the responsibility of the judge to provide the judgment. So while that support is available to him or her, it is only support. But the actual the process and the work of delivering a judgment on a case which may have run for 1, 2 days or 2, 3 or 4 weeks is the responsibility of the particular judge who's heard that case.
Yeah. And I suppose in terms of resources, like the way to cut down on delay is to ensure that the courts are more properly resourced, isn't that correct?
Yes.
And to have more High Court judges appointed so people can get their cases heard promptly. And I suppose the first type of delay, the delay of not getting your case on, that is ultimately the fault, not of a judge, but the fault of the state and resourcing, isn't it?
Yes.
Okay. Can I just ask Flack, in terms of the proposal that the Bar Council made, like, do you have the same concerns, Eilish, about, or Sinead, about the legislation as proposed in the general scheme of the bill? Do you have a preference for it to be dealt with in the Circuit Court, or do you think having an assessor is the correct way to deal with it? Or have you an open mind in it?
I think we largely have an open mind, but just with the caveat that we don't think that just having an informal system will exclude the requirement to have lawyers assisting the person making the application. And we say that because the processes before the courts can be quite mysterious to the particular client. They don't really understand why their case has gone back and other cases gone forward, why their case is put into a holding list while another case goes ahead, why they have to wait for the respondent to do a particular thing. And I think in that regard, to make that into a case for compensation will require the lawyers that were involved in the case to actually sift through those various elements of delay that can happen and waiting, and decide which ones were unreasonable or which ones to say or claim are unreasonable or which are not. So we don't see that you're going to wholly exclude the participation of lawyers and therefore make this a cheaper, more accessible system, and I think that needs to be taken into account.
I suppose there was attempts to do that, I think, with the establishment of PIAB. I know it's one of the statutory bodies you referred to, but lawyers aren't excluded from that.
Yes.
And I suppose it is a matter for an individual, like what we're talking about here is an individual trying to have their convention rights vindicated. So it's an assessment of whether or not their rights have been breached by the state, and presumably they're entitled to have lawyers to assist them in that.
Yes, I suppose our concern would be that if lawyers go to these assessors and there's no provision for some version of legal aid, that whatever award they get will then be diminished by the fees that they're going to inevitably end up paying the lawyers, and that intersects, I suppose, with our point about how quantum is to be determined under the proposed legislation.
I think one of you made the point about an appeal, where the scheme, I think, allows for there to be an appeal by an applicant against any award, but the Minister seems to have a broader right of appeal. Was that made in one of your submissions, sir? Can you elaborate on that?
Yes, I mean, the system which seems to be established by the Heads of Bill is that an appeal shall lie to the claimant from an award made or in respect of any award made by the assessor. Now, what that seems to mean is that an award has to be made in order for the right of appeal for the claimant to arise. But of course, one option which would be available to the assessor, or whoever the decision maker may be, is to refuse to make an award. And the way the Heads of Bill are currently drafted, they would seem to mean that the claimant wouldn't have an appeal from a refusal to make an award. Okay. But the Minister has an appeal from any award which is made. So once any money is awarded to a claimant, the Minister has an appeal, but the claimant only has an appeal against a certain species of decision made by the assessor, and that seems to us to be inherently unfair in that it deprives the claimant of what is undoubtedly an entitlement and a right under any system of law.
And Sinead, can I just ask you, you mentioned in your submission about the quasi-judicial bodies, such as the WRC and the RTB and PIAB. What percentage of people coming into FLAC would have issues concerning their rights which relate to the quasi-judicial bodies that will be determining it? Are there many of them that...
Well, I suppose the main area where we would be working would be around social welfare. So the Social Welfare Appeals Office, now there may be a debate as to whether it's a quasi-judicial body or an administrative body, but I would know that clients we would have would now be waiting even over a year to get an appeal heard, and this is the most basic safety net of social security. So there are concerns. Historically, there were huge delays before the Equality Tribunal that went on for up to 3 years. That has now been resolved with the WRC, but that doesn't preclude that those bodies that it can happen again. And we don't see that there's a basis for wholly excluding those bodies, either as a matter of cumulative delays. So if you end up in the courts, it doesn't mean you haven't spent 2 or 3 years dealing with your issue before a quasi-tribunal body before you even get there. So why would you truncate the compensation somebody would get? But also, why shouldn't somebody be able to recover some kind of compensation if their issue before the quasi-judicial body wasn't determined?
And are you aware, has a case ever been taken against the state because of the delay of the Social Welfare Appeals Tribunal, or are you aware whether any claim has been taken to them?
Not that I'm aware of. Presumably, if it becomes excessive, that would become a matter of judicial review if somebody would have the resources to do so, but they're very unlikely to have the resources to raise that issue in the first place.
Yeah, there was a case taken against the former Equality Tribunal for a delay, and the High Court found that a delay of 3 years wasn't inordinate, but that they recommend it wasn't successful. Could I just ask, I mean, you mentioned 2 different forms of delay that occur, but I suppose in FLAC's experience there's huge delays in legal aid, so before people even get in the door of the court, there can be delays of over 6 months in getting access to a legal aid board solicitor, and the legal aid board solicitors will primarily only be dealing with family law. And then there's a significant amount of people who are trying to represent themselves, who are lay litigants who are before the courts, and they contribute to delay because they find the whole process so difficult and so inaccessible. So there were serious hits to the court services, and particularly the IT part of the court services during the recession, and there is a real need for there to be huge investment in the court services and in things like the website to make forms and procedures much more accessible, and to provide for the lay litigant who may never be represented before the courts.
So there's a delay which starts from the time a person wants to invoke their right to challenge what they say is the injustice up until the determination.
Yeah.
And part of the delay you're emphasising precedes what we're talking about here, but it's just as significant.
Yes.
Like, how many claims have there been on it? Do you know, Micheál or Conor, how many claims there have been each year for general delay against the state, or is it a common occurrence each year?
Don't have the figures on it,
Okay.
but we would not envisage that there'd be an avalanche of such claims. It's difficult to predict with any degree of accuracy. There have been one guide to indicate that it is a significant systemic problem, is that there have been a number of successful claims in Europe itself, in the ECHR, before the convention, where Ireland has pretty well held up its hands in many of these cases and said, we're terribly sorry for the delay, we're going to improve our position and get it sorted. And in the most recent one, as we've tracked in the paper, that was precisely the approach. But the Strasbourg court said, look, that isn't good enough. We've been saying this for years. And it was acknowledged by Ireland that indeed we have been in violation of the Article 13 in terms of giving an effective remedy to citizens for a long time now.
Okay.
So really this is a timely piece of initiative. we respectfully suggest it should be refocused.
I'm just going to finish. In terms of the scheme, is it intended, or do we know that the assessor would adjudicate these cases in public or in private?
We don't know, it seems, but I think if we can read into the heads of bill, it seems to be envisaged that it would be largely a paper exercise in that there is a requirement that the decision would be made on the basis of written reports, and there doesn't appear to be any obligation on the assessor to invite submissions or invite any oral evidence, so to speak. So I think we can deduce from that the intention from the heads of bill at least appear to be that it would be a paper exercise and therefore carried out in private. But I think, if I might just add, because a point that Flack made, and I think it is one that bears emphasis, is that the heads of bill seem to envisage a very streamlined process, and we can deduce from that it's to be largely a paper exercise. But the ECHR itself has said that the decision as to whether there's a culpable or a compensatable delay is one which has a degree, and sometimes a significant degree, of legal complexity to it. And on page 10 and 11 of our main submission, members of the committee can read that in due course, but we identified the considerations which the ECHR have said have to be taken into account when deciding whether there was a delay and what compensation that should attract. And because of the legal complexity which they have identified as being in this question, it is one which litigants may require legal assistance and legal advice and representation on in order to advance their claims. And it would be dangerous, in our respectful submission, to have any system which precludes an individual from availing of legal assistance or legal representation in advancing their claim. And that in itself could become open to challenge.
I suppose just finally to answer the question Mick raised, I suppose one of the benefits from the government's point of view of establishing an assessor system and a separate office, if it's going to be dealt with in private, that they're not exposed to the embarrassment of significant delays being exposed in public in the circuit court. But you don't have to comment on that. Listen, the final thing I want to do, I just want to express my condolences to Micheál O'Higgins on the death of your former colleague Garrett Cooney. He was a very fine barrister, played a very significant part in the development of the Irish legal system. I had the privilege of knowing him. He was a splendid barrister, and I just want to pass on my condolences to you. I think he was a former chairman of the Bar Council as well.
Thank you, Dr.
He was a very formidable person.
We'll mention that to his son, whom, as you know, is a practicing barrister, also Garrett.
Thanks. Thanks, Chairman.
And the committee would like to associate with those words of sympathy.
Very much.
Deputy Jack Chambers, please.
Thanks, Chair. like to thank the witnesses for coming before us. Just a couple of questions. Like I know a lot of it's been covered. I know you spoke about, obviously, we hear this all the time, more resources being the end-all solution to lots of difficulties we have in terms of public administration and bureaucracy. Aside from that point, is there anything you'd propose around the reform of the actual court structure and the difficulties that exist within that? Because for me, when I look at all aspects of, I suppose, the public service, and I include the court system in that, you know, more resources isn't always the answer either. So I'd like to know, in terms of the administration of our court system, do the Bar Council have any ideas about how, you know, in line with extra resources, how the court system could reform some of the definite inefficiencies that are there and are there because of judges too? So I don't believe more judges would lead to better, you know, it may lead to an improvement, but I don't think it would automatically lead to better outcomes for people who'd be affected by this. So just initial thoughts on that.
Well, yes is the short answer. As the representative body for barristers, we're constantly engaged with the notion of the systemic reform. And in fact, as we speak, I think it was yesterday or if not last week, we finalised a submission to a review that is underway at the moment on the civil justice side of the system. So not the criminal side, but the Superior Court civil justice system. And Mr. Justice Peter Kelly, the President of the High Court, is conducting that review across a range of areas. For instance, judicial review, which is associated with supervising the powers and activities of lower tribunals and lower courts in the High Court, and also the whole area of discovery, which is sort of a big issue in litigation, and the costs associated with discovery, the delays that discovery brings, and undesirable aspects of discovery. And what we did, we've very much engaged with that process that's underway. Various interested parties have put forward their views, not just lawyer groups, but court service officials, those involved in the system, with a view to trying to achieve efficiencies, trying to improve access to justice, which is what really this should be all about, and also creating a situation where members of the public are informed about their rights, so that they're encouraged to go to court and participate in what is a very important forum for the vindication of their rights. And these initiatives take many forms, but one simple path that we're following at the moment is an endeavour to try and make the law less mysterious and to use plain ordinary English in legislation, in regulations, and in actual submissions that barristers make. And there's an encouragement being given to people, I know it seems an odd thing, but to actually speak in the English language rather than in obscure, old-fashioned legalese, which unfortunately has, certainly in the past, and perhaps not only in the past, has been a feature of the system. And to make that more accessible, more relevant to litigants and for members of the public, so that they will avail of the courts and so that they will know their rights and have an opportunity to actually access to courts to vindicate those rights. So that's another project that is very much underway, and a lot has been done under that heading, but more remains to be done. But yes, I agree with you, Deputy Chambers, this is not a simple case of a call for more money or resources to be thrown at the courts. Just as I'm sure those who are advocating for reforms on the health side would say it's not all about appointing more doctors or more nurses or more hospital porters or whatever it might be. It's about channeling those resources and improving efficiencies and reforms in the system, so that a better product is delivered and a better service is provided for members of the public. So we very much are aware of that. So that is why we don't just call for an increase in resources, but in fact a correct channeling of those resources.
And has there been any, can you point to anything the last number of years that has improved in terms of reform within the system?
I can. There has, In 2011, there was the judicial review system for accessing the High Court for bringing challenges to lower courts or tribunal decisions, or decisions, for instance, under allocation of housing or social welfare matters and so on. That system was overhauled and a new, what's termed Order 84, was introduced. There's actually further reforms underway to further hone and refine that, but that's an important matter. It's somewhat on a legal footing, but at its heart it's simply an attempt to make the system more straightforward, more understandable, more streamlined, and actually to cost less.
Yeah, and
that's one example. There's a range of others. Judges are more and more aware of the necessity to speak in the English language and to communicate with people. It's not I don't suggest it's a fully achieved and concluded project. Some lawyers, unfortunately, still tend to slip into legalese occasionally. I'm sure I'm guilty of it myself, inadvertently. But more and more people take the view that the best lawyer is the person who connects with non-lawyers who are maybe at the back of the court or in the audience. And that is something that we're very much conscious of.
Just in terms of, obviously, that point of your submission was around resources and allocations rather than having the assessor model. What about for the individual involved and the cost to them? I know you mentioned the cost to the state. So obviously, establishing a structure would have a cost to the state. But would the risk and the cost to an individual not be greater to go to the High Court than it would to go through a new model that could vindicate the right potentially? And have you weighed that? I'd like to hear maybe Flack's view on that as well. Like could it encourage people, if there is an informal basis to vindicate their right, that the risk is less than if they were to spend a huge amount going to the High Court where they may not be vindicated? And I think that's something I see is people's fear of the law and the court system and just going near it despite a very clear-cut issue that they have. And maybe by having structures outside of a system that they feel is completely inaccessible to them, it might provide for potential vindication of their rights. I mean, I suppose that's just, I don't like to hear all your thoughts on that.
Well, I suppose the first thing, we're not suggesting or advocating which court should deal with any claims, or we're not suggesting it should be the High Court. The reason we identify the Circuit Court as the appropriate court is because the Oireachtas has already identified the Circuit Court as being the appropriate court to deal with claims under Section 3A of the Act. And so from a consistency point of view, we don't see any good reason to depart from the model that has already been put in place by the Oireachtas as recently as 2014 when that amendment was introduced. In relation to the substance of the point, which is would a court-based system not be a disincentive to individuals? I suppose one point to emphasise about that is the appeal process which does exist. So an individual, if the assessor model as it's currently framed is established, an individual can bring a claim to the assessor, but can that, if he or she is successful in that claim, that award is then appealable by the minister, by the state. So and that appeal goes directly from the assessor to the High Court. So the individual is then essentially dragged into the High Court despite not wanting to be there. So the avoiding a court-based model at first instance doesn't avoid an individual ending up before the courts. So for that reason, it seems to us there to be no good reason why the individual shouldn't simply go to court and be permitted to go to court with his or her claim. The second point in relation to that is the one thing that individuals want is for their claim to be determined in a fair and transparent manner. And as I mentioned a few moments ago, one of the things which the ECHR has said very clearly is that the question of a delay and compensation for delay is one of complexity. An individual doesn't want his or her complex issue to be determined by an assessor on the basis of paperwork and written reports. The claimant, in some cases it will be straightforward, but some cases won't be, and the claimant will want to have his or her say in relation to whether compensation should be awarded. Equally, the assessor model which is set up deprives the state of the right to participate at that first stage, because it seems that the claim goes in and that the state has no right to participate or make submissions in relation to whether or not compensation should be awarded. If compensation is awarded, there is then an automatic appeal given to the state to go to the High Court, not the District Court or Circuit Court, but directly to the High Court. So there doesn't seem to us to be the disincentive which you mention attached to a court-based system rather than an assessor system. And in fact, it would seem to us that the assessor system is one which provides for greater curtailment on an individual's rights and entitlements to have their case disposed of fairly and transparently.
Do you have any thoughts on that?
Really, sure, Sinead, just like to.
I suppose we're not tied to any particular model, but we're concerned that whatever model is adopted, that it would be accessible, that it would be quick, and that it would be low cost. And I suppose the current, you were asking earlier about, you know, how the court system could be improved. I suppose it would be our concern that the current court system model is predicated on the fact that people will be represented by lawyers, and there's a whole lot that could be done in that regard in terms of simplifying forms and simplifying procedures. So there are things that need to be kind of taken into account in whatever system is decided on. Is there something, Sinead, you want to?
Yeah, I suppose just to add on your original question around efficiencies, and to go back to another European Court decision, which was Airy in Ireland, and which prompted the introduction of a civil legal aid system. There's still a really huge question as to whether we're complying with that decision in terms of our present legal aid system, the number of exclusions, the time it takes to get legal aid, the financial threshold at which you qualify. And I suppose that feeds into the efficiencies as well, because we've all seen that there's been an exponential rise in lay litigants going before the court. And often judges have to spend a huge amount of time, and they're very good at this, but they don't really have that time taking the lay litigant through the procedure and trying to guide them through the system so at least they can get their case heard. Often those cases are misconceived. If the person had access to a lawyer, they would know that at an earlier stage, and they expose themselves to costs. But that is a cost on the system that a properly functioning legal aid system might at least diminish and improve efficiencies as well.
Thanks, everyone.
Okay, Deputy Chambers, thank you very much. And finally, Deputy Donnacha O'Leary.
Chairperson, and thank the witnesses. I suppose I will try and be as brief as I can. I actually have to depart to a debate there around 10 to 4 kind of thing. So just one or two quick questions. I suppose firstly, just echo the points made by, I suppose to support the points made by both by Flack and the Bar Council in relation to access to justice and resourcing of the court service. It's an issue we're very conscious of in our Sinn Féin's pre-budget submissions. The last few years we've advocated additional resources for the court service to improve access to justice. I suppose just initially there, just to ask the question there in relation to, I suppose this follows on from an ECHR decision. Prior to that, was the idea of compensation for delay, so far as you're aware, ever considered by the Oireachtas or the Law Reform Commission? Is an idea that's been floating out there in your knowledge?
Anybody like to take it up, David? Nobody? No. Yeah.
Certainly, around for a long time is the idea of the possibility of bringing constitutional action by reason of court delays. The discrete looking for compensation issue is newer again, but it has been found at any rate that the most direct form of compensation to give for court delays, for the stress, the additional stress and the disappointment and so on associated with that, is an award of money, compensation. But it is quite how when it first came into the system, we're not sure. But what we have tracked in the paper is the amount of cases for a long time now that have actually gone up as far as the ECHR itself, where the Strasbourg court has found that Ireland is in default, and that remains the case.
Okay, very well. And I suppose just to ask the question, obviously some of this, and this is again a general question, obviously an awful lot of this would fall onto the assessor, or in your view, the courts, but like, I mean, is there much ECHR jurisprudence on what constitutes an unreasonable delay. Like, I mean, obviously, you can have a delay that's not unreasonable. So, like, I mean, is there much jurisprudence on that, or is there a high order of criteria? Or?
There is. The emphasis has been on an examination of the subject matter of the proceedings and the level of complexity involved in the proceedings themselves. So I suppose the ultimate question that the assessor or the judge, if it was the model we're suggesting, would look at would be the relative causes for the delay and the justifications for the delay. It's not possible to give, it's not simply a question, and the ECHR case law makes this clear, it's not simply a question of looking at the raw level of the length of the delay, but it's a question of measuring the delay and assessing how culpable it is in the context of the nature of the proceedings that were an issue, what was at stake for the litigant, and whether the justifications put forward on behalf of the responding party pass muster at all. So it's measuring those and weighing up those justifications against each other, and with the view to arriving at an answer to the question: was the delay unreasonable? Has it been justified? And is it just now to award compensation by reason of the delay? And of course, the other thing that has to be borne in mind, again, the ECHR jurisprudence treats of this issue, is an assessment of the impact which the delay has had on the individual litigant. Some litigants would be stoic, can deal with a lot of delay, maybe a young person who isn't terribly bothered, versus somebody who's highly stressed or elderly, or perhaps not long to live, or whatever the particular personal circumstance may be. So all these things feed into the measurement. And we're not suggesting that every case is hugely complex, but many of the cases have these complexities that, to our mind, necessitate. And the Oireachtas, the drafters of the draft bill seem to acknowledge this, because they've provided that it should be a judge or a retired judge who is the assessor. So for that reason, it appears to be common case, as it were, that these are things that are somewhat complex, or certainly have the potential for complexities.
Okay. I suppose a question that I would ask to Flack and to yourselves is, like, I mean, you're saying that it's not clear whether that there will be hearings in public, or that it seems to be largely a paper exercise. So I suppose, like, that being the case, is it your view that there is a need for, if it's not currently provided for, is there a need for an opportunity for some form of hearing, some form of opportunity for the aggrieved party to put their case in person? Or is it best that this does remain a paper exercise, and that's the most effective way of conducting it?
Would you like to take it first this time?
I think probably a flexible approach. I mean, sometimes if the delay was something really straightforward, like a case was heard on X date and it took 3 years to get your judgment, there probably isn't going to be a huge complex need, you know, to have somebody examined and provide oral evidence. But if it's been a long protracted case with many kind of loops in it, and where that delay needs to be explained, and also it will be unclear how the impact on the person could be understood purely on a paper basis, without the opportunity to present their direct evidence to an assessor as to what the impact has been and what was the importance of the case to them on a personal basis, or it could be on a commercial basis or whatever. But oral evidence does have a value in that regard, and to totally exclude it would seem to be incorrect. But there may be cases that can be perfectly decided on the paper without any particular difficulty. Okay. So I think both approaches are possible, but you need to keep the opportunity for an oral input into any hearing or determination.
Okay.
Particularly for claimants who are unrepresented or who may have literacy problems, who may not just, the paper exercise may not just be suitable.
Actually, sorry, as a follow-up to that, like, I mean, I presume, I may be wrong, but I presume that Flack would consider that obviously this area should be an area which you could get legal aid for, I would presume.
Well, we consider there should be legal aid right back at the beginning. Yes, obviously it followed through all the way.
Okay, very well, thank you.
We'd respectfully agree with what has been suggested by Sinead and Eilish for Flack. One point that I think does bear mentioning is this. One advantage which not doing things in secret, and one advantage of providing an oral hearing, even if it's streamlined and informal and hopefully cost effective, is that there's a tremendous value in a litigant feeling they've had their day in court. And if that is full court or quasi-tribunal or whatever shape it takes, there's a difficult to calculate advantage and positive thing about a litigant feeling, I had my day in court. And the barrister, she stood up for me, told the judge there was a wrong done here, and even if I've lost the case, I come out of court feeling somebody was advocating for me. Those positive benefits will follow if it's a transparent court-like hearing or quasi-court hearing. They won't follow if it's done in secret in some unnamed office purely on the paper. And that's another thing we think should be borne in mind.
So there is just one particular feature as well. The Section 3A system, which is a claim for compensation for an unlawful detention, which is directed into the Circuit Court by the European Convention on Human Rights Act. That claim can only be made when there's already been a finding by a court that there was unlawful detention. So the substantive issue has already been decided, and what's in effect being decided by the court in that instance is the level of compensation. The system that's being set up here is that the first thing that has to be decided is, A, was there a delay? The second thing that has to be decided is, was there a culpable delay? In other words, is the state guilty or responsible for that delay? And the third thing is, how much compensation should be paid? And those first two things, under the system that's proposed, those first two things, which are really the substantive findings which have to be made, are being passed to an assessor, which on the face of the heads of bill is to determine those issues on the basis of the papers. Now, if one draws the analogy of the unlawful detention point, that would be like having an assessor deciding on papers whether a person has been unlawfully detained or not, which doesn't allow that person to make full submissions or representations, and doesn't allow the person who is alleged to have unlawfully detained the person to make submissions or make representations as to whether the detention was unlawful. So it seems to us that there's no reason that it's anomalous to have the more complex issue, which is the compensation for delay, put into an assessor system, but the more straightforward issue of compensation for a detention which has already been found to be unlawful to go into the Circuit Court. That seems to us to give rise to an anomaly.
Okay.
Thank you.
Just one or two other points there before I wrap up. I suppose to ask the question, obviously delays can be caused by a number of factors. Delays can be caused by simple complexity, and it's not an unreasonable delay. Delay can be caused by the resourcing issues that we've touched upon. I suppose delays can be caused in some instances by a judge perhaps not discharging their responsibilities adequately or quickly enough. I suppose just to ask the question, both Oflac and the Bar Council, are there areas that the court services, that the legislature needs to address in terms of the administration of the courts? Are there systematic improvements that can be made aside from resourcing, that can improve the effectiveness of the courts in dealing with cases?
Your light was the first to hail it, whatever triggered it, so we'll let you take it.
I suppose we just repeat in terms of making forms and procedures more accessible for the lay litigant and providing for the lay litigant. That's something that could kind of improve the system and make it more accessible and may reduce in the long term delays.
Yeah, I'd agree with that. I think some of these points were made earlier already in terms of processes and how court rules can be approved. Funnily enough, we did a submission recently, and one of the observations was it's almost easier and more straightforward to introduce a High Court case than a District Court case, which makes no sense, but procedurally it's actually easier to do it and more straightforward, so there's definitely huge scope within the rules to streamline, make it much more straightforward to bring your case, get through the court system much quicker.
Okay, yes.
And from the Bar Council?
Just picking up on what Sinead said there, we've been, some of our submissions, perhaps it's because of the questions that have emerged, we've been answering it at a level of the High Court or perhaps the Circuit Court. In many ways, the most important court in the land is the District Court. That is where, on the criminal side, that's certainly the most important. It is the one which has the most, where citizens of the country have the most interface with and contact with the criminal justice system, and equally on the civil side, so persons looking for debt collections or whatever the case might be, aggrieved at a dog barking next door, whatever it might be, they have the district court perhaps as the most important, because it involves the citizenry being in contact with the system most frequently. So all of these points, I hope, it's a request. We're trying to treat of these issues with regard to the sort of high level of High Court or Superior Court level, but these points have even greater relevance and impact with respect to the lower courts, where the business of the country is more frequently transacted with the citizenry of Ireland.
Very well. Final point there, and it comes, well, the two related points, but they both are from the same head, I think. That's just from your own submission, but if the Bar Council want to comment as well. Just maybe to elaborate on the point that there is an inconsistency that you've identified with an approach. This is Head 8, Compensation and Quantum. You've identified an inconsistency with the ECHR Act 2003, and my understanding is that it's something related to the fact that compensation is on the basis in this bill on ECHR principles, and that is not necessarily that it's sort of a compromise between the different jurisdictions that would exist across the ECHR, obviously some of which are very, very different economically, socially, legally. So if you can comment on that. And then there was an additional point you made that, like, I mean, obviously this would apply equally to the alternative that the Bar Council has put forward, but the difficulty of a perception of a lack of independence or a conflict of interest if a case relates to delay in determining the quantum of compensation, and the compensation might have been determined by the High Court, and then it returns to the High Court under this process, and that there would be a perception of a conflict of interest or lack of independence, even if there are different judges, that there would be that perception, if I'm understanding that point right. So maybe just if you can just elaborate on both those points, and if the Bar Council can maybe address it briefly as well.
Yes, I think this was our point in relation to Head 8, and that quantum is effectively being linked to the approach of the European Court of Human Rights. I suppose our point here is that the state is really required to put in place a remedy that's effective in a domestic sense, rather than replicate a remedy that might be available to a litigant that takes the very long road to get to the European Court of Human Rights. The difficulty here we perceive is that quantum before the European Court is quite different to what would be awarded by the Irish courts in similar type cases, but that's because the European Court is doing a completely different job when it decides a case against the state than what an Irish court is doing when it decides, or a quasi-judicial tribunal, when it decides a dispute before it. So often the European Court will say, we have decided that there has been a breach of your rights, and simply that act of deciding a case in your favour and declaring that there's been a breach of your rights is adequate compensation to you, or just satisfaction, as they call it, and it often won't provide any remedy in damages at all. On other occasions where it does look at providing remedy in damages, it's often an amount that might well be a very effective remedy in Bulgaria, but would hardly pay your flight to get from Ireland to Strasbourg if you were to go there to have your case heard. And similarly in relation to legal aid, that can be awarded by the European Court. So it's kind of apples and oranges, and while we should be providing for apples, we've ended up providing for oranges, and that seems to be the proposal. And I think if we were to go back before all these cases that went before the European Court and found Ireland in default, if we actually had a properly functioning system of compensation for delays that was operating in a domestic sense, there never would have been finding against Ireland. So it was the absence of a domestic remedy was the issue. But there's no need now to bring in a European remedy and try and transplant it into the Irish context. So there seems to be, to us, no real justification for making that direct linkage there, and that direct linkage is not made in the European Court of Human Rights Act 2003, which is the main legislation providing remedies for breaches of the Convention. The other problem we have identified, which is probably speculative to some extent, is that what if there's an excessive delay in getting a remedy for a breach of your rights under EU law? Somebody takes their case before the courts. Where are they to go for a remedy for that? And if there's already this machinery being put in place by the state for delays, why shouldn't it accommodate delays in whatever context they arise, whether it's EU law or a breach of Article 6 of the Convention? So again, it seems to be a misplaced notion that this is purely a remedy that should sound in the European Court of Justice rather than before the domestic courts. The other issue you've raised is about this kind of loop that seems to be put in the legislation where an award is made, that goes up to the High Court to be approved, but then the court that approves the award then will hear an appeal in relation to the award. And while no doubt a High Court judge will act independently if considering an appeal, nonetheless it could create a perception that it isn't a wholly independent appeal if the same forum has already approved the award beforehand. And that's just a basic point, but it just maybe needs to be considered.
Okay, thank you.
And the Bar Council, would you like to add to that?
I think everything has been said eloquently there.
Yeah.
There's very little to be said. We've made one point in our paper to do with a restriction that is implicit in the model that's been selected for the bill, which we think either is directly unfair or certainly could potentially be unfair, and that is the provision in the same head that Sinead discussed, head 8, where it is said that in making an award of compensation, the assessor shall compensate the applicant only to the extent that he or she suffered injury, loss or damage because of the breach. And we say if that's intended to mean, for instance, you must produce a medical report to show a psychiatric injury or such like, we say that would be setting the bar too high and would cut away people who have suffered stress, who have suffered a loss of enjoyment of their life, who've had an unnecessary disappointment visited upon them. That would cut them away from a right of compensation, and we think that would be a mistake. And we've said that in the paper as well.
Just on, if you could just address the point of this loop or whatever you wanted to characterise it as, I suppose that would apply to the model proposed by the Bar Council as well. That, like, I mean, a court could be in a position, the High Court in particular, and then would have to adjudicate it on its own delay.
Yeah. I suppose it's the system that's proposed at the moment is that the assessor would decide it and then it would be approved by the High Court. But in the event that, for example, the assessor will decide it without the state being involved in the assessment, it would then go to the High Court without the state being involved, and the High Court would approve the award, say for the sake of argument. The state would then have a right of appeal against that award, and the appeal goes to the High Court. I think that's FLAC's concern, in that the same court will be deciding on the award and also on the assessment. We don't see that in its on the level of principle as being a difficulty, because High Court judges day in, day out have to exercise independent judgment and independent decision making. So we don't see a difficulty with a High Court judge hearing an appeal where a different High Court judge has already approved the award, because they'll be hearing different arguments and will have the benefit of the argument made by the state. But what we do think it underlines is that the drafter of the heads of bill have identified that this is a very significant issue, that the question of compensation for delay in proceedings is a very significant issue, so significant that it warrants the High Court actually being involved in deciding that the award is an appropriate award. And to us, the point that underlines is that it is a matter which is so significant that should actually be determined by the courts in the first instance rather than an assessor. And we don't see why, other than that somebody in drafting the heads of bill have identified it as being a significant issue, we don't see any other reason why the High Court could be involved. If the High Court is going to be involved in approving the judgment or approving the award in the first place, why not simply have the courts determine the substantive issue and the quantum of damages, but by putting it into the Circuit Court if it's to be consistent with Section 3A or such other court as the Oireachtas may determine to be appropriate.
Okay. All right. Donncha Goramahagat. Well, that leaves me with nothing else to do but to sincerely thank Conor, Micheál and David and Eilish and Sinead. Thank you all for your attendance here today and your participation, and your colleagues who have joined you in the visitors' gallery below. Just to say that other business of the House has clearly impacted on attendance, and I apologise for that. There are 11 members of the committee. So I'm particularly grateful to those who made the time and avail of the opportunity to engage with you. Your views, both in terms of your written submissions and your responses to the various questions posed, will be hugely beneficial in our preparing a report on this particular proposed legislation. So again, to thank each of you and to wish you all a very happy 2019 and success in all your work undertakings. So the Joint Committee is adjourned with myself just remaining. It's very simple. I'm sure it never happens at court. But the Joint Committee is adjourned until our normal time of 9 a.m. on next Wednesday, the 23rd of January, when we will be addressing equality and rights in the context of Brexit. Very interesting subject and very relevant at this point in time. Thank you very much indeed. Caoimhghín Ó Caoláin.